So thank you so much, everyone, for joining us for our February edition of Seeds Ask the Expert. This time we have brought our seed team as an expert for intellectual property from an investor's perspective. It's an online session led by a lot of times different experts from the industry. But this time we have got our seasoned inventor and advisor, business advisor, Archie Gillis, with over 30 years of experience developing, patenting, commercializing technology across softwares, hardware, mechanical systems, and creative industries. Archie offers a practical, real world look at how intellectual property can help founders protect their ideas and scale their businesses. So, today, you will learn about the strategies, lessons, and insights Archie has gained from working with innovators, engineers, researchers, and global tech companies, making it an invaluable opportunity for all of us who's looking to strengthening their understanding of IP as a business tool. There will be time at the end to ask questions, however you can, like while the session itself, you want to drop in chat or raise hands, you're more than welcome to hop in and ask the question. Archie, take it away. Thank you so much.
Thank you, Priyanka. I see someone else is in the lobby there too. Um, all right. Well, thank you all for joining us today. Some of them faces I recognize and some I do not. So feel free as I go through, if there's a question, um, to just jump in because you may forget otherwise. So I'm okay with that. That's fine. Um, and if for some reason you can't hear me well, let me know and I can adjust the I can try to adjust my mic because I have had a few issues with that. So just keep me informed rather than having me go on and on. Or if you can't see my screen for some reason. And so again, thanks to Priyanka for inviting me to do this. I work here at CEED, Center for Entrepreneurship, Education, and Development, and I've been here for, I think, almost 4 years now. But I've been in the business development workspace for almost probably about 20 years. And I also have over my lifetime developed products, software. Um, I literally did a pitch to Invest Nova Scotia at 11:30 today for their Accelerate program with the team I'm working with now to develop a new piece of software. So that was fun. Um, but what we're going to do today is I'm going to give you some general information on intellectual property, but I think that you can find that information online or through ChatGPT or through traditional resources. So I also want to give you my experiences. And so when I say ask the expert, I'm referring to myself almost as an expert user of intellectual property. As a musician, I copyright my songs at the Library of Congress in the United States, and I'll tell you why I do that and not in Canada. As a user, I have patents in America and in Canada, and have worked with different companies, and I can explain what those experiences were like working with different engineering firms, and they're not all the same. Not all patent lawyers are the same. There's good ones and there's bad ones, and that's the stuff that you cannot find online. And so, any questions with my own personal experience, and I do want to mention I'm not a patent lawyer. I'm not a patent agent, and nothing I provide today is legal advice in any way, shape, or form. It's more my story and kind of general information that you can find online. And at the end, too, I can also point you to any extra resources that I use, such as Google Patents or the United States Patent and Trademark Office or Canadian Intellectual Property Office, which I worked for 10 years. I worked in the Canada Business Service Center and I shared an office with the Canadian Intellectual Property Office. So I'd always be bugging Tom about patent questions and or Cecile Klein. Some of you may remember them. Now they've retired, but it was nice to be surrounded with that, especially myself as an inventor. And so that's a little bit of history about me. And I do even have some slides of some projects that I've done to give you some ideas. And then if you have some questions, you might have your own idea. And I can talk about what you may want to share and what you may not want to share because there's all kinds of landmines that you may want to avoid with disclosure, which can mess up inventors or intellectual property folks. And so I'm going to jump through some of the content relatively quickly, but I'm happy to go back through anything as we move forward as well. Um, so I think that's kind of all the housekeeping stuff. So I'll jump into the slides here. And so the first slide as we roll along. Kind of the question is, well, what is intellectual property? I think of it as, something a business generally is going to use to assist you with making money. Now, patents is one of the sandboxes that I play in. I have I think 4 or 5 patents, depending on how you count them. Trademarks is a great tool. East Coast Lifestyle, we've all seen that. That was trademarked by Stuart Haynes at Cox and Palmer. I've used him as an intellectual property lawyer myself, and I remember seeing that in his work. And that's quite a valuable trademark. And so a lot of the businesses we work with at CEED here also protect their trademarks. Copyright, that's another one. I use that for my songs. I've copywritten songs, but you can copyright software and other literary works. And last but not least is trade secrets. And there are actually other intellectual property out there, but we're not going to cover everything under the sun. These are kind of what I think of as the core. And so trade secret is sometimes when you don't want to incur the costs of, for example, patenting something, you may just be like, you know what, we're going to keep this on the down low, kind of like Colonel Sanders' secret chicken recipe. I don't think that they have any IP on that. I think they just keep it a secret. And I think the Coca-Cola formula was a secret as well, but I'd have to, don't quote me on that. I'm not 100% sure. But the whole idea is that you want to protect the commercial value. You want to kind of give yourself, um, for example, in patents, it's a monopoly for a duration of time, usually about 20 years. Copyright can last up to 70 years after the death of the creator. There was in the news, you might have heard that the first version of Mickey Mouse fell into the public domain, and Disney fought that tooth and nail to try to extend that. And they did extend it for a while, but now Steamboat Mickey Mouse is a public domain character, meaning anybody can use it. But you'll also run into other things like Creative Commons licensing and stuff like that, which we won't get into too much today. But there's a lot of intellectual property out there. And as we move on, if you guys have some that you're looking into, I mean, some of your questions might be answered here as well as we go. But so if you're an inventor or creator, you might want to say, well, why should I patent or register my music or my creation or my book? But it creates an opportunity. It creates a monopoly for 20 years in some cases, and 70 years after you die in the creation, like in copyright. So there are risks. If you don't protect yourself, competitors, if you have something that's making money, competitors sometimes do flock to that and copy you freely if you don't protect it, right? And so you have to think ahead. Sometimes after the fact is too late, right? And that's what we'll talk about disclosure as we go on. And so the first topic I'm going to just briefly touch on is copyright and what it protects. And it's things like literary works, artistic, dramatic works, music, uh, um, software code. And that's a good for me to express as well is different countries, different jurisdictions may have different lengths of time. And that's true in copyright, trademarks, patents, everything. Like in some countries, it might be 50 years. In other countries, it might be 70 years. And there might be all these uh, different durations or even different rules in what can be protected and what cannot be protected. Even between Canada in America, there can be significant differences. And we're starting to even see like intellectual property doesn't just stay the same with all this artificial intelligence stuff. And I'll get to some of that later as well, because it's very relevant today. Um, it's a big mess right now, and they're not really sure about some of that stuff. If you train on this data, is it infringement? Right? And we'll talk about that as a interesting discussion point. So one of the things I do as a musician, um, um, I perform. A couple of years ago, played on the blues album of the year for East Coast Music Awards, but I used to tour in my younger days a lot as well. Um, and so I've played with all kinds of different groups and music groups and had songs on radios and get little royalty checks from Spotify and things like that from time to time. Um, and so why register copy? Sometimes you're worried, you write a song or you write a book, maybe you write the next Harry Potter, and you're scared. You're like, I'm going to put this out into the world. And maybe you should be even more scared now that AI might take your idea and run with it, or try to modify it slightly, right? And then what can you protect? So when I was registering my songs, I noticed that in Canada, all they did was register the title. And I was like, well, what about how the song sounds and the melody and the harmony and the words and the flow? But it was $63 Canadian is what it costs. But I was in the United States because I could deposit the work. In the old days, I sent a digital CD down. Now I send the audio files. They accept the files. And I feel a bit more comfortable because I can, send the embodied song. And that way, if it ever becomes debated, if I did make the next, number one country hit or whatever, I would have some recourse rather than just saying I've registered the title. And it costs about relatively the same. And the other nice thing is you can copyright 10 songs at a time for the same price. So it's relatively cheap. Copyright is kind of cheap and easy, which is awesome. Patents are enormously expensive, painful, and difficult. So we can have a chat about that too, if you like, and determine should I or shouldn't I? Because there's risks in not patenting, but there's also significant risks when you do patent. You're risking a lot of time, a lot of money, a lot of resources that might be better served um, going elsewhere, especially depending on how broad you can kind of stake a claim to the material that you're looking to protect. Um, so trademark's different than copyright. Trademark's kind of for little things like words, logos, slogans, even sounds. Like I remember when I turned on my Mac, the in the old days anyway, that the Sosumi sound they called it came up, and the Apple showed up. Ding! They actually trademarked that sound, which was pretty interesting. But the trademark I think of is the East Coast lifestyle one, because that's really pretty interesting and pretty valuable. But also thinking of Apple, there is a fun story about how the Beatles owned Apple Music Publishing, and they had that company, but it's also a trademark. And so um, trademark sometimes you don't necessarily, depending on how it is. In Canada, you get a trademark just by using it, right? Um, and different countries have different rules. But in the Apple case, Apple computers, they've had a trademark on Apple for a certain group of of things or items or products, I guess, products or services. So you can't say I'm going to own Apple everything, Apple computers, Apple cell phones, Apple glasses, Apple televisions, Apple chairs. That's too broad. Now, you could file a whole bunch of different trademarks and cover those. But what happened in the Beatles case, the Beatles owned Apple Music Publishing. Apple Computers owned Apple Computers. But Apple Computers started to do music when iTunes came out. Now the Beatles were upset and sued Apple. The Beatles became quite happy when Apple paid them $1 billion to buy the trademark from them. Then they licensed it back to the Beatles. So not only did Paul McCartney and the crew do well on their songs, just by the fact that they named their company that. Now, I think Steve Jobs might have named Apple computers after something to do with the Beatles, but I'm not 100% sure on that. We'll have to look that up. But trademarks can be quite valuable. I mean, they say the Coca-Cola trademark is price well, not priceless, but you know, is a key element of the value of their systems. And so you'll see things like the McDonald's arches, um, and stuff like that. Now, sometimes if you've determined, maybe you've come up with a process or an invention or even a workflow that you don't want people to know about. Maybe you've discovered a workflow that, you can't even get a patent on it and you can't copyright it. There's no trademark. Or you've come up with an invention, but you don't want to spend, $10,000, $15,000 on lawyer fees and patenting fees. Then you might be better off to kind of keep it under your hat and make it a trade secret, right? Um, so that's kind of something to think about as well, and to determine. And it can be tough. It can be a tough choice to figure out how to do that. So the next little step here is patents, and I'll talk about my history here with those in a few slides as well. So what can an inventor patent? Well, it has to be something, a process or a method, or an object, something, a product, but it has to be novel, useful, and what they call non-obvious. That's a tough one, and that's probably the hardest one. They try to say, well, if we knew about this and we knew about this, and we stick them together, anybody who's trained in that field would have done that, and they say that that's obvious. So you have to often to get a patent, you have to debate with the patent examiner and say, no, they wouldn't have known about that. They wouldn't have thought to put that together. And that's like debating club. You have to kind of have some skills in that and say, well, no, they wouldn't have known about that. This is what we call a eureka moment or an inventive step moment. Because otherwise, they don't grant you a patent if they say it's looks like no, that's an obvious thing. And maybe we'll think of some examples later, but sometimes it's when you hear somebody comes in, oh, I have an invention to do this, and you're like, well, that probably falls under. It's kind of like it sometimes feels like you know it when you see it, but to try to describe it is a little tough. But if you meet those requirements and you have something, novel, non-obvious, and useful, then you may be eligible to file a patent application. Um, and so patent application, you can filing it is relatively inexpensive. In Canada, I think it's $237 because I filed one not very long ago. Um, and you can, for a year, kind of a year to 18 months, I'll say, but for a year, it kind of buys you time. You can kind of just file a disclosure, a simplified document, just the title and a very detailed description and specification. And then you can feel some comfort that you filed that invention, where then you might tell tell an investor, or find a partner or something like that. Um, you can submit what they call patent claims or patent drawings as well, but you don't necessarily need to until after that year, because sometimes you're like, oh, I have this great idea. Let's see if we can find some interest. So it's a cheap way to kind of, dip your toe in the water and see if there's interest in the project or in the invention, right? And so the other thing, which I'll get to in a minute, is you can file in Canada, and then you can file in other countries, but get the date of the Canadian filing if you do it within that first year as well. And that sounds a little complicated, but oh, I just saw a question there. Where do you file this? So you file your Canadian patent application. I do them online at the Canadian Intellectual Property Office, CIPO. If you look that up on the internet or on a search engine, or one of the AI tools, you can file your patent application there. And you need a description and a title. Drawings maybe optional. Claims are optional as well. But after that clock runs out of that 1 year time period, you have to have your application completed. So it's almost like you have a year to complete your application. Um, the specific, the specific. Let me just open up the chat here. When you say,
I mean, sorry, hi, my name's Marguerite.
yeah.
So I mean the anatomy of a patent. Like you said, you can do something that's not quite the full, you can put in something that's not quite the full patent application, but it's kind of a
Yes.
stopgap between. I'm wondering, because I've been on the site, I've never seen this, a place I could put something like that.
Okay. Yeah. What you do is you log in, you make an account at the Canadian Intellectual Property Office. So you do have to make an account, and then you can upload your documents there at that point in time. So maybe you haven't made an account. And then what that does is,
Yeah.
yeah, in America they call it what's called a provisional patent application. We don't have that in Canada, but essentially what you have is you just upload the specification as a PDF, or as I think they accept maybe Word documents as well. Where it is at, I mean, I don't want to go off and go on to the site. I would reach out to CEPO themselves. If they do have a helpline and they have a phone number and an email, if you do have trouble navigating the site, whether that's for patents, copyright, trademarks, or whatnot, they are quite helpful. And like I said, they used to have an office here, but I don't think that they still do, but you can still reach out. Hopefully that kind of addressed your question. Um, and so moving along, there is a process if you're an inventor. You need to search. You have to be novel in the world. Nobody else in the world can have done what you've done. That's not that easy to do, right? So that's something to keep in mind. And draft and file. That's the first step that I talked about. I do it in Canada. Some people, ideally, it makes sense to do it in your home country. Then it goes and it's published on the internet in the patent database, right? The other thing to keep in mind, which I might not have mentioned, is if you publicly disclose your patent or your invention, in a lot of countries, that will mean that you cannot acquire a patent in that country. So you have to be very careful about what you disclose prior to filing your application. So that's kind of the key thing to remember. If, like, I even had a client at CEED here who shared their invention with the group without a non-disclosure agreement. And so that might constitute public disclosure, which then sets a clock ticking. And so it's better to not do that until you research it further, or file your application, or get people to sign non-disclosure agreements, right? Then after that, you go through what's called, you have a expert in the field examines your invention, and they'll tell you thumbs up or thumbs down, and you can fight it. And each battle you pick, though, costs quite a bit of money, especially if you're using a patent attorney or a lawyer. But if you get it, then you just have to pay some maintenance fees, which are not, well, they can be costly in the States, but for the most part, aren't insurmountable. But yes, so here's the public disclosure thing I was talking about. There's some grace periods in Canada. Let's say I went and I like researchers at universities sometimes do this. They'll publish in a journal. They'll say, "Oh, I discovered this," and then they realize, "Oh, this is patentable. There's like $1 billion of value here." And then they're like, "Oh no, what do I do?" Well, they have 12 months to file a patent application on that, even though they publicly disclosed it. Same with the United States. So North America, awesome. Europe, though, and a lot of other countries, you're done for, right? It's over, right? It's not novel anymore. Your own invention means that you lose all patent rights in Europe, Japan, China, and other countries. If you could have afforded to do that anyway. And we see here that if you do want to file, I won't go into too much detail because it is complicated, but if you do want to go international and try to get your invention protected in other countries, you can be talking thousands and thousands of dollars. So, easily for a complex invention could be $50,000 to cover it in, 3 to 5 countries. Here we say 100 to $500,000 for 8 to 10 countries for a full portfolio, just for one invention, but a portfolio of patents that protect that one invention in those different jurisdictions. And so even the big companies sometimes only file in like America and Europe and some of the bigger markets, because the costs just become expensive. Here we can see what it really costs. Canadian patent, probably depending on the complexity, 10 to 25K. American, 10 to 30K. And then some maintenance fees. So the other thing is, and I've done this myself, is I've not followed through with a Canadian patent because the American patent, there's 10 times the market size, right? So focus on the market that is most lucrative. But there is something to be said about once you do all the complexities for one country, it does simplify the other country, but there is still the filing fees and expenses of those sorts of things. And for small entities, micro entities like you and I, as opposed to Apple or Google, we get significant discounts on some of these expenses. Thank the Lord, because it can be quite expensive. So I'm just going to walk you through one of my inventions from years ago. This was my first patent, was on a musical instrument application, Gillis capo system, which I still kind of have on a back burner. It's I've got other projects on now, so I've back burnered this, but I've been working on this for years and was granted a patent application on it. But I'll show you how it started. Just started with me with an idea and these drawings, and I have books of these drawings trying to make a what I call a capo system for this guitar. Just think of it as a mechanical device that Archie thinks is awesome for his musical instrument. So my first step was think of the idea, and I just drew it out, tried to figure out how's this going to work. The next step was take those drawings and turn them into some sort of more sophisticated engineering system. And so I designed these with help from Dalhousie, with a mechanical engineer there, Rob Warner, who was awesome. And we did these up, and then we were able to prototype by 3D printing some of the elements, especially the inserts. We tried to 3D print the other parts, but mechanically it was just not happening. So we had to make those out of brass. So the next step was to use the computer-aided design system. We 3D printed the parts, tested it. Then I had a nice prototype. But 3D printed parts were not necessarily strong enough. They were strong enough for a prototype, not strong enough for a commercially viable product. So then I went to the next step. I made a mold, made it out of reinforced plastic, so on and so forth. And then you'll see this is the final system. I got my little capos for each individual string. I've embedded these little plastic parts in the neck, and I made these line of guitars. This is one of the guitars I had made. So what I did was I made my specifications. I ordered musical instruments from overseas to my design specifications with this little hole and the parts that I wanted. And this one has the capos in it, although you don't see that. This guitar here in this picture, I actually sold to Jack White of the White Stripes. So he owns that now. But on top of that, I've also done other projects. I've done mechanical projects, electrical projects. This is one where I did a invention where these are guitar pedals that magnetically attach and just magically transfer data and power. So that was a project that I did a number of years ago. And you can do it for iPads. It's kind of like the MagSafe connector on your Apple computer, if you've ever seen those. And they just magnetically lock together, and then you can share data. And it's modular computer units. So that was another invention that I did. And I also had a team of electrical and software engineers at Dalhousie that I partnered with, and we built some different prototypes and means and mechanisms to get this stuff working. And there's about 1,000 stories with each of these projects. Even the project that I pitched this morning is again different. But as an inventor, it's I don't know what to say. It's just kind of like sometimes it's just what you like to do, like if you like to play guitar or music, right? It's just kind of inherently part of the mix, I guess. So before we jump into questions, there's a few fun things or fun topics that I thought I would introduce to you, some real world challenges, and then some extras, and then we can have a chat about it for the last little bit, because that might be fun. So some real world challenges are sometimes I've seen, I actually had a family member who started a company, a tech company. Great idea. Didn't have a patent on it or anything like that, but started to get some traction, then started to get some cease and desist letters because somebody else had a patent on it, and he did not research deeply enough. Is he allowed to do what he's doing? It seems like, well, we live in the capitalism. Uh, Canada is a capitalism country, but that patent gives that person with that grant uh, the exclusive monopoly right to do what they're doing. So those cease and desists, you could ignore them and get sued. And we hear of those companies like the Beatles had enough money to sue Apple. They're like, hey, we're not standing down. We have enough cash to fight for this. So that's called freedom to operate. And as even just a generic business, sometimes if you feel that you might be infringing on somebody else's rights, you can engage legal services and have them do a freedom to operate assessment on what you're doing, and then that is legal advice. It's expensive, but it's more expensive to launch an entire business, maybe getting hundreds of thousands of dollars of investment and research and development, just to realize that you're not allowed to do what you wanted to do. It can be absolutely devastating to a company. Right now, sometimes you can pay a licensing fee and it's okay, but then it's like that's also fraud with challenges. The thing I stress about with patents is the deadlines. I'll file. As soon as you file, clock starts ticking, and it's just like 12-month priority deadline. And it can get expensive, right? If you can't find investment, sometimes it's an insurmountable challenge, but it depends on your situation, right? If you have investors, or if you're rich, or if you have Uncle John, or if you can talk an investor or a group or team of investors into it. I've done that. I've done all of those things, right, through with different projects that I've done. So there are options out there. Some are easier than others, and some are more difficult. So the stress of deadlines can be something to keep in mind. And then even if you do get a patent, sometimes one thing is the patent broad enough that it means anything? Like sometimes you can get a patent on something, but you fight with the patent examiner, and it becomes so narrow in scope that it doesn't really protect much of the invention. And so you're just doing it for the sake of doing it. And that's expensive. The other drawback is, can you even afford to litigate if somebody infringes, right? Can you afford $500,000 to take them to federal court and sue them, right? Now, I don't want to really quote on what it would cost, but it can be, it's not cheap. Now, if you have, sometimes it's enough to scare them away, or they will pay a fee, but it does often become a David and Goliath scenario. So that's something to talk about. The other thing that we can discuss is NDAs and non-disclosure agreements, which sometimes if you're looking for investment, or you're worried about sharing your own idea with an investor or a researcher or an expert in the field, sometimes that can give you some comfort that they're not going to run off with your idea. And a few extras that I thought were fun and that are starting to come up in AI. And literally last night I saw Matthew McConaughey talking about protecting himself, his image, his trademark, him as a human, because actors are in trouble, right? And here, one of these guys is Brad Pitt. The other guy just looks an awful lot like Brad Pitt, like enormously like Brad Pitt. So when someone makes a new movie with Brad Pitt, why not just hire Chad Witt to play that role, have him do all the AI movements? And so it's an interesting scenario. This is a different type of intellectual property. It's your personality rights, your publicity rights. And what's coming down the pipeline now is all of these AI rights, AI likenesses. I've also heard that there's 60,000 AI songs uploaded to Spotify every day, right? So what's going to happen when there's, 1,000 movies uploaded to YouTube every day or whatever? And I cannot tell you guys the answers to this. And even this stuff, you know, um, is complicated, but it is fun to discuss and see what it is. It's like, can you make money from your own face? Can Brad Pitt sue you? Can Brad Pitt sue this guy? This guy was born this way, right? Does Brad Pitt have the rights to sue his doppelganger? Um, and what IP does this fall under? So the reality is, certain things are allowed and certain things are dangerous. So you're allowed your own identity. You're allowed to license your own image, your own voice, your own stuff, as long as you don't mention Brad Pitt in your marketing. Now, if your name is Chad Witt, or what if your name was the same? That would be an interesting legal fight. But generally, you cannot sell yourself as the Brad Pitt avatar. You can't say you're the Brad Pitt lookalike in advertising. You can't say you're the next Brad Pitt. You can't imply that you're Brad. Um, and so if you do that stuff, you might be safe. But if this happens to you, then you may want to get legal advice. But it's an interesting uh, thing, right? So now people are starting to, figure out how to contract themselves, how to protect themselves in this world of AI. And I'm sure that they're going to try to protect AI generated personalities as well. I'm sure that that's coming down the road, although there's certain rules now even starting to be enforced about if it was 100%, let's say a song 100% created by AI, then you don't get a copyright on it. But if you had some impact on that, I'm hearing that there could be some claim to some copyright. Um, and last but not least, a couple of fun stories. Google. A lot of people don't realize that a lot of people don't think you can patent algorithms. You can in a clever way if you embody them to a computational device. Google did patent what's called the PageRank system. I always love the story because Larry Page tried to sell it for $1 million, even got knocked down to $750,000 in 1999. Tried to sell it to Yahoo and then Excite. They all turned him down. In 2002, you see how quickly the value of Google went up, mostly based on that one invention of Larry Page's from Stanford, Larry and Sergey, the founders of Google. In 2002, in just that 3 years, it grew to a $5 billion valuation. Yahoo walked away again. They're like, you're nuts. That's way too expensive. Well, Google's market cap today, what they're worth, is $3.8 trillion. So they should have purchased it probably. Another fun story, I grew up in Cape Breton, pretty close to where Alexander Graham Bell grew up. My grandfather would have lived down the road from him. He tried to sell the telephone to Electric Union, who thought it was a toy, and he wanted to sell it for $100,000. But they were like, no one's going to want to talk on the telephone. Hindsight's 2020, right? So I find that story interesting. Alexander Graham Bell. There's some great books. There's a great biography on him that I have, and there's some other stories. One called The Telephone Gambit. That's interesting if you like that. And last story is the Tesla Edison battle of the inventors. Basically, there's even movies on this about Tesla versus Thomas Edison. Tesla didn't make out too well, but he did win the War of the Currents. But poor Tesla, Edison said, if you can solve this problem for me, I'll give you $50,000. Tesla solved it, and Edison's like, of course, thanks for sharing all this great information and working for me. But I was just joking. I'm not paying you $50,000. So, note to self, get it in writing, if something like that happens. So that was the betrayal. Tesla quit working for Thomas Edison, and he went out, partnered with Westinghouse. And so Edison lost the war. The currents, Westinghouse made all the money, and both Tesla and Edison lost out. They could have been partners, and they could have powered the world, but that they did not. So, in summary, I know that's a lot of information. And I would suggest that if you need more information, there's some great booklets on the Canadian Intellectual Property Office website, and you can even reach out to them and call them and talk with them. And you might still be able to set up an appointment or a Zoom. I have to check into that. But they have booklets on patents, trademarks, copyrights that can really get into the depths of this stuff, especially the general knowledge. And then if you're still having challenges, intellectual property lawyers and patent agents are expensive, but if you see the value there could be some value in setting up an initial consultation to see what it might cost and how much it will be. Sometimes they offer them, a discussion for, always want to ask, does it cost to have an initial consultation? That's important. But to summarize my workshop today, and I now realize that I did try to stuff a lot in a short amount of time. IP is a business tool. Understand it before you build. Use it as a tool to kind of make money, essentially, and make sure that it has value. That's the key thing. Is does it make sense for you to do it? Don't disclose everything before you learn what disclosure is going to, how disclosure is going to impact your rights in the future. That's trick number 2 to be aware of. The third one, it can be an enormous expense. I often say avoid it if you can, because it is difficult, and there has to be a lot of value. That's the other thing. It's a long-term commitment, and it might extract all the money from your business, where sometimes first to market and move fast and break things, sometimes that's a better way. So talk to your business advisors, experts, other people in the field. A freedom to operate is the other one. Make sure that if you're doing something, you're allowed to do it. Worst thing, you invest $500,000 in something, and then you're like, oh, not allowed to do it. Waste of money. And last but not least, I am not a patent lawyer or patent agent, so anything I said today, proceed as if it's not legal advice, just a story, my own experiences, things that I am interested in and investigate. But professional help, a good patent lawyer, they might save you. Imagine if Alexander Graham Bell or Google had messed up their patent applications. $3.8 trillion for Google, right? So that would have been an awful mistake. And so that is my PowerPoints. Any questions?